The state experts. Okay, I got a decision to make now because I can't do a 6-hour show. So we're only 13 pages into this. So I think I'm going to have to break this into multiple shows. So the main issues here, of course, are the medical examination, which is mostly fake science, testimony at trial, and the lying of the police supervisors about the training. I think I'll break it up along those lines. Does that make sense? That sound reasonable to everybody? And then within the next day or two, I'll try to do a follow-up. Let's see. So this is doctor stuff. Oh, the supervisors. All right, this is the lying cops. Let's jump to this. The Minneapolis Police Department. 3 witnesses with supervisory authority over tactics, training, and policy would testify at trial. Chief Medario Arradondo, Inspector Katie Blackwell, remember that name in particular, Lieutenant Johnny Marcell, also worth remembering. Arradondo had been chief since 2017, was responsible for the entire MPD operation. Blackwell reported to Arradondo in her duties as commander of training. Those duties included the training of street cops pursuant to written policies, including the manual. Lieutenant Marcell oversaw defensive tactics training, focusing on use of force in arrests. 2 relevant policies were in place on the date of Floyd's arrest, 5-3-11 and 5-3-16. These 2 policies authorized knee to neck restraint techniques by officers to include compression of the neck with an arm or leg. On August 28, 2020, defense counsel made a motion to dismiss the charges for lack of probable cause, counts 1 through counts 3 of the criminal complaint against Chauvin, citing those policies, 5-3-11, 5-3-16, and a photograph and a PowerPoint training slide presented to police officers during their training. That photograph, we'll see it in a moment. It's called Bates 2596 is how it's referred to in the court. And here it is. So here's 2596. And you can see there's 3 officers here. And the officer on the left has his knee on the notional suspect's neck, right? This is in a training environment. And the bullet points say sudden cardiac arrest typically occurs immediately following a violent struggle. I mean, this is a police document, so it's very poorly worded. What they mean is when cardiac arrest happens in the course of an arrest, it's typically after a violent struggle. Place the subject in a recovery position to alleviate positional asphyxia. And of course, all these things you do this when it's practicable to do this. For example, the suspect's attempting to fight for a weapon, you're not worried about the positional asphyxia at that point. And I would argue if the suspect's at risk of excited delirium and death, you would prioritize mitigating the risk of excited delirium and death over this, especially if the suspect is talking, because then they're not asphyxiating. Once in handcuffs, get EMS on the scene quickly. Of course, Chauvin and the other officers did that. Sign a transport hold, complete a CIC report. That was all done. And here's another photo. Chauvin on the knee. Look, Chauvin doesn't he look like a vicious murderer? He's staring here, by the way, at a crowd of 20 or 30 or 40 people standing on the sidewalk, filming him with their cameras. Like any murderer would do. By the way, I know it looks here like Chauvin may have his hands in his pockets. I think this photo really hurt him, because it makes him look very casual. I don't think his hands are in his pockets. I think he's wearing black gloves, black latex gloves. So I think his hand is just kind of resting on his upper thigh in case he needs it. The state filed a motion in limine. A motion in limine is a motion to exclude evidence. Filed the motion to keep the photographs Bate 2596, that's this photograph, the training photograph, out of evidence. Why would the prosecution not want this photo to be in evidence? Think about it. The primary argument prosecutors advance is that Chauvin, the prosecutors, the state, the police, and the prosecution claim that Chauvin never saw that presentation during his time as an officer. He never saw those photos, that training, so he wouldn't know. In his mind, his mental state, he wouldn't know that was an allowable technique. You see how weak an argument this is in the first place? It doesn't mean he would have been taught it was an inappropriate technique, right? If he used it spontaneously, su sponte, without ever having any training, if he used it, and coincidentally, it turned out, although he had no training on it, it was permitted. Shouldn't the jury know that? In any case, as we'll see, they're lying about the fact that he wasn't trained on it. The state told the trial court that Chauvin would not have received that training with that image because, let's see, the presentation had never been included in in-service training. In-service training is training that officers get after the academy while they're active cops. As a result, prosecutors claimed Chauvin would have never seen that training or that photograph, and that made it irrelevant and inadmissible in the trial. The state was quoting from an email sent from MPD officer Nicole McKenzie to a DPS agent, Department of Public Safety agent James Rayerson, on which Blackwell, remember I told you to remember her name? She was the commander of training, in which Blackwell was copied on the email. The relevant portion says, "It's been brought to my attention, there's been a request to provide additional information about the slide included within the Excited Delirium presentation. The Excited Delirium presentation was originally created for the MPD Academy. Cadets and recruits received that training in the academy. To my knowledge, this presentation has never been included for in-service post-academy training that we conduct." So they're implying that Derek Chauvin wouldn't, this was not in the academy when Chauvin went through. Chauvin went through the academy 20 years prior. And that therefore he didn't see it in the academy, and it wasn't used for post-academy for in-service training. So Chauvin, they say, would never have seen this training image and known that this was a permissible technique. In fact, however, another trial exhibit is the training attendance log for November 30th, 2018. Under training course is defensive tactics as taught in the academy. On the second line from the top is Derek Chauvin's name, post number, and badge number. And in that training course, that image was used. So we know, in fact, Chauvin did see it. On March, after the state filed the motion to get that image excluded, here we go. Inspector Blackwell met with prosecutors to prepare for trial. She told them the neck restraint was technically authorized, but she would have stopped if she'd seen Chauvin doing it. Inspector Blackwell was shown the photograph, the PowerPoint, noting a knee on the neck. She agreed that placing someone in a recovery position should have happened within seconds. On March 12th, Marcell, Lieutenant Marcell, the trainer in use of force, and a team of 9 prosecutors met to prepare for trial. He told those present they got away with putting knees on the person's back in time. They got away with putting knees on the person back in time, but have since changed the protocol. That training officer was shown the Bates image, the training image, and another image from the Floyd incident, and noted only a difference in weight placement and not a violation of policy. So even then, Lieutenant Marcell, both Inspector Blackwell agreed it was technically authorized and it was not a violation of policy. The state was successful in keeping that training image out of evidence, but defense counsel did not learn it was not going to be allowed into evidence until 2 weeks after jury selection had begun. So trial counsel could only impeach, could not introduce that as evidence himself, but could only introduce that photo to the jury if one of the police supervisors testified that they had never personally been trained on the tactic. Then he could pull it out and say, well, you weren't trained on this? He could use it for impeachment purposes to contest something they were saying, but he could not introduce it as direct evidence. Of course, then the police supervisors would be trained never to say these words, not to open the door to the image. So that did not happen, and the jury never saw the photo in Bates 2596. Again, it's this photo with this knee on the neck as part of the training for MPD officers. Remember, Inspector Catewell says the neck restraint was technically authorized, and Lieutenant Marcell, the training and use of force, says it was not a violation of policy. In the wake of this ruling, 2020 typo, in the wake of this ruling excluding that image, prosecutors called the police chief, Arradondo, to testify. They said, I must ask you, is this a trained Minneapolis Police Department defensive tactic? The chief said, it's not. Remember, they're talking about this, folks. They're talking about this, the knee on the neck. Is this a trained tactic in front of the jury? Police chief says it's not. Does it violate department policy? I absolutely agree it violates our policy, says Arradondo. Ask him again. Is this not a trained neck restraint? Correct, that's my testimony. It's clearly untrue testimony. Inspector Blackwell, in charge of the academy, took the stand later in the day. Is this a trained technique? It is not. I don't know what kind of improvised position that is. That's not what we train. Just a lie. And this is what the jury's hearing. The next day, Lieutenant Marcell, in charge of use of force training, was asked, is this a trained neck restraint? No, sir. Has it ever been? Not to my neck restraint, no, sir. All lies. Then, to make matters worse, the state returned to this testimony of the police chief, Inspector Blackwell of the Academy, and Lieutenant Marcell, use of force trainer, in a graphic during closing arguments. And here's that graphic. Arradondo violates use of force policy. Commander Blackwell, I don't know what this modification is. Lieutenant Marcell, not a trained technique. And during closing, the state argued to the jury, remember, Inspector Blackwell, in charge of all training, looked at this and said, I don't even know what this is. I don't know what this modification is. That's not how we train. These aren't the rules. Lieutenant Marcell looked at this. He said, without equivocation, that's not a trained tactic. Unreasonable force, unreasonable, not proportional, excessive. It violated policy. It violated the law. And that was the basis of Chauvin's conviction. All lies. This is interesting. This is a wrinkle I was not aware of. So remember, Inspector Blackwell lied about the training. She was head of the academy. Well, someone wrote a book critical of her testimony, and she sued them for defamation. So on October 17th, Liz Collin and Dr. J.C. Chakes published a book, They're Lying. The book was critical of the testimony presented by Inspector Blackwell in State v. Chauvin, calling into question Blackwell's testimony related to the restraint that Chauvin, Lane, and Kung deployed. The book made 3 statements in connection with the testimony. I'm going to go through this, just hit the relevant points here. In late 2024, so just last year, folks, Inspector Blackwell filed a lawsuit alleging defamation of character against the authors for their representations in the book, that they were lying. They were not telling the truth. Maybe she was lying. Since that time, 34 current and former MPD officers have come forward to provide sworn statements that the Minneapolis PD trained them to use a knee-to-neck restraint in a variety of situations, including as part of the maximal restraint technique when there's concerns of excited delirium. All 34 are attached and incorporated a representative sample in the words of these MPD officers under oath. Not only was knee-to-neck, upper shoulder restraint trained, its use was common and part of policy. Numerous MPD officers participated in the training. It certainly wasn't secret. I know numerous MPD officers were trained to place their knee on the side of a subject's neck when dealing with a combative subject. It was common knowledge. It was trained in the open. I saw numerous MPD officers perform it in training and in the field. Numerous officers participated in the training. I described in the declaration. It certainly wasn't secret. It is necessary for an officer to pin a person to the ground while handcuffing the person. An officer's use of knee-to-neck and upper shoulder restraint was common during use of force training. So this was now a defamation suit by Inspector Blackwell against the authors of this book. That defamation suit was dismissed this April 8th of 2025 by the trial judge pursuant to a special motion. Let's see. And I'm going to give you some more details on that case because I think it's interesting. So the case was dismissed. It was dismissed with prejudice, by the way. And Inspector Blackwell, who brought the lawsuit for defamation, she actually had to pay the book author's legal fees. And she agreed to that, which means the only way she had to pay $75,000 and the other side's legal fees. Why would you agree to cough up $75,000? Because they were threatening to go to trial and ruining her in this lawsuit. So as a condition of them being agreeable to settling, she had to pay their legal expenses. Now, what were they settling? They had said she was lying about the training, the lack of training for the knee-to-neck restraint. She sued them over it, and then she ended up settling and paying their legal fees. The settlement agreement contains several images of officers that were taken during training performing the knee-to-neck restraint used by Chauvin. It also included, get this is rich, the settlement agreement also included a photograph of Inspector Blackwell herself performing the same knee-to-neck restraint during the 2014 riots in the city. She did it herself. She used this neck restraint herself. That lying little biatch. In its order settling the case, the Blackwell court specifically addressed the testimony during the trial, the one that the book wrote about, the testimony the book wrote about, that Katie Blackwell said was defamation. The Blackwell court, the defamation court, found found statements 1 to 3. These were the book author statements saying that Blackstone was lying. The settlement court found that those statements by the author that Blackwell was lying were substantially true. The authors were being substantially truthful. Specific findings by the settlement court in the defamation case: police policy and training were at odds with the officer's testimony, including Blackwell. Her statement, "That's not what we train," and her dismissal of the image as an improvised position reasonably invites viewers, jurors, and now the public to conclude that the depicted technique was never trained by MPD. That's not true. Training materials from 2018-19, the period of her tenure at the academy, included images of officers applying knees to the neck or upper back. MPD's own policy manual, 5311, in effect at the time, defined a neck restraint as including compression with an arm or leg. This conflicts with Blackwell's suggestion that neck restraints were trained using only arms. And in her testimony, Blackwell stated the restraint used by Chauvin was not something we train, yet the department's own policy manual and other officers indicate that similar techniques were part of training materials. And to settle this case, remember, she's settling it and writing a check for $75,000 for the other side's legal expenses. So she still has to pay her lawyers. And she's writing a check for $75,000 to the book authors. She had to agree to this. I, Inspector Katie Blackwell, acknowledge, agree, and affirm that everything in the settlement order, all of this, is accurate, true, and correct. And it's in direct contradiction with her testimony at the Chauvin trial. Just contemptible.